On Tuesday, the United States Supreme Court heard arguments about President Biden's student loan relief plan, which could cancel up to $20,000 of debt for some borrowers. The supermajority conservative court seemed skeptical about Biden's authority to enact such a program, but also questioned whether the challengers even have legal standing. This relief plan would affect more than 43 million Americans. And to give you a sense about how much the cost of college has skyrocketed over the years, the justices deciding the fate for millions of Americans paid an average of just over $42,000 to get a higher education. Today, they'd pay more than $320,000. Joining me now is Joyce Vance, former United States attorney in Alabama and an MSNBC legal analyst. She's also the co-host of the #Sisters-in-Law podcast. More importantly for me, she's one of the most brilliant legal minds that happens to be a friend, so I'm always grateful that she spends her time with us on the Katie Phang Show. Joyce, good morning. Let's start with standing. Why would a lack of standing give this Supreme Court an off-ramp to decide these cases? I mean, even Justice Amy Coney Barrett questioned if there was standing here.
So standing is a legal doctrine that says not just anyone can go into court and sue. You have to, as lawyers like to say, be someone who has been gored by the ox. You have to be someone with skin in the game. And here that means you have to be someone whose legal rights are touched upon by this legislation or by this executive action. And it also has to be something that the court can remedy for you. The standing argument, which, as you can tell, Katie, from this sort of convoluted explanation, is a hyper-technical doctrine. But what it comes down to here is that the states that are suing, perhaps not individual defendants, but states, don't have standing because this executive action by the Biden administration wouldn't impact them. Sure, there are parties that might be impacted, but they have not chosen to sue. And so typically in a case where there is no standing, like in this one, the court simply dismisses the case. They stamp it dismissed for lack of standing, and that's the end of it. And that's what the court would do in this case if it treated it like every other case.
Joyce, let's move on and talk about the major questions doctrine. It's rearing its head again in this case. We heard it when the EPA basically got a little bit destroyed last term with this Supreme Court. This major questions doctrine seems to be a very convenient ends justifying the means way for this supermajority conservative SCOTUS to get where it wants to be on certain types of cases. For me, it seems pretty hypocritical that Republicans complain about judicial activism, but isn't that exactly what these conservative justices are doing in this instance?
I think you're describing the major questions doctrine in exactly the right way. It's an ends-oriented doctrine that's not worthy of the Supreme Court. In fact, it's relatively new. It's not hinged in any major constitutional principles. This is what the court says. Unless Congress is really explicit about the authority of the executive branch to take some really important action that we, the conservative majority on the Supreme Court, don't like, then the president isn't entitled to do that. As you pointed out, they did it in the EPA case involving setting levels for greenhouse gas emissions. You know, its use in this case is particularly hypocritical because there is legislation, the HEROES Act, that permits the president and by extension the Department of Education to take this sort of action, remediating student loans in the face of a national emergency. COVID, clearly a national emergency when Biden chose to act in this regard. And that justification would seem clear for anyone who's committed to following the text of the law, something that the conservative majority claimed it was committed to doing for years, but apparently not when there's someone like President Biden in the White House.
Let's take a quick listen, Joyce, to Justice John Roberts, and I'll have a question for you on the other side.
I think it appropriate to consider some of the fairness arguments. You have two situations. Two kids come out of high school. They can't afford college. One takes a loan, and the other says, well, I'm going to, try my hand at setting up a lawn care service. And he takes out a bank loan for that. At the end of 4 years, we know statistically that the person with the college degree is going to do significantly financially better over the course of life than the person without.
Joyce, I was astounded with the complaints from Justices Roberts and Gorsuch about, quote, fairness. Those justices didn't seem to take that into consideration when they overturned Roe v. Wade and the Dobbs case, which impacted millions of Americans. But isn't it intellectually and legally dishonest to talk about fairness when the text of the HEROES Act allows Biden to do exactly what he wants to do here?
You know, what Justice Roberts is calling, quote, fairness there is really Republican policy arguments for why Joe Biden should not have made this decision. And the Supreme Court is not a policy-making body. The issue of whether it's fair to relax student loan requirements like has been done in other industries, right? I mean, there's been relief in the auto industry, relief in the airline industry, tax breaks for the wealthiest Americans. So that's the fairness argument about whether something should be done here for student debt holders. And that argument belongs in the Congress of the United States, which chose not to act. What the president did here was to take action that the administration believes was warranted by the text of the HEROES Act. The Supreme Court's job is to decide whether or not legally that was the correct decision. And I think this is a giveaway. This fact that the court has strayed into the policy arguments tells you a lot about what's animating this Supreme Court. It's not the legal decision making it's supposed to limit itself to.